Also, with the consent of the other side, my lord, item 4 to item 8, I have taken consent from the senior counsel, my lord. Can it be on 1st of June, my lord? The AG was supposed to appear, is out of station, my lord. Taken their consent, my lord. 1st of June, my lord, they have proposed.
Yes, Mr. Das.
Yes, 1st of June can be, but your lordship, I have heard that your lordship sits on every Thursday in the environment bay, in the
Yes,
second half.
Hmm.
In that case,
6th will be better.
but 6th I have a matter.
Then do it on 13th.
Yes, yes, that is.
Mr. B. Gogoi Lanet, standing counsel, Health Department, Assam, respondents and all.
Well, let it be on 1st, my lord. At least we will complete our part, my lord. Again, he will not be.
Yes,
there.
yes.
I can't
Case
say-
for adjournment in this case on the ground that the Advocate General, the learned Advocate General Assam, who is appearing in this case, is unavailable today. The prayer has not been opposed by the petitioner's counsel, but a request has been made. Post these cases for hearing again on 1/6/2023. In view of the above, admission hearing of these matters stand adjourned till 1/6/2023.
But
Register to list the cases accordingly.
Obliged.
May it please the lordship. I beg for a listing of a contempt petition lordship on 24th. It was filed on 11th, then it was listed on 28th of April, but it remained as leftover. Thereafter, I approached the judicial register judicial for listing twice. It is
First
not-
listing, no order passed.
No order passed. Obliged lordship.
May I please, your lordship? I pray for listing of a read petition, that is WPC number 1571/2019. This is on 23rd for hearing.
No, the sleep and hearing, this is not possible. Suddenly, we cannot suddenly allow mention sleep and fix matters for hearing. You get it for orders first.
Yes, lordship. Much obliged.
26th for orders,
Much obliged.
26th May for orders.
May I please, your lordship, I am praying for listing this two matters for hearing. This is 2007, same order.
26th for orders, not for hearing.
May I please, your lordship, I beg to mention the writ petition. It's of 2016 matter. It's related to pension matter, your lordship. It's
Yes. Yes, you have it on 29th for orders.
much obliged.
If I may please your lordship, I beg for listing a matter for admission. It's a promotion matter
Hmm.
for the post of grade 3 post. Where the respondents have not taken any action so far
Choose a date after 15th June.
after 15 June. Your lordship, another matter for listing.
Hmm.
This case was earlier mentioned on and was held on 10/3/23. And the counsel for respondent number 3 side where to file his vakalat number after the holy vacation. I have approached the registrar
Hmm.
and it's a long queue, so I have to come again.
Orders on 12th June.
For 12 June.
May do lordship. Lordship, this matter I am praying for listing for orders, lordship. Matter was listed on 10, but it was leftover. And the appointment of a Gaura was set aside without giving any opportunity. So matter.
5th of June.
Yes, lordship.
May I please, your lordship, with the consent of the other side, I beg to mention item 24, lordship. We have sent the affidavit for vetting. Kindly 2 weeks time may be granted for filing of the affidavit.
Item,
24, lordship,
you are for whom?
for High Court, lordship.
A prayer for adjournment has been made by the learned standing council GHC on the ground that the counter affidavit proposed to be filed in this case has been sent for waiting. Since the prayer is not opposed, same stands allowed. This matter stands adjourned for 3 weeks.
And for the
Much
petitioner.
obliged. Lordship.
Obliged.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 21. Your lordship may kindly adjourn the matter for the day and
You are for whom?
for KAC.
Lordship, I'm appearing on behalf of the petitioner. Kindly fix a date next week.
Then we'll take it up today.
Lordship, the
Next week,
conducting counsel Jay Patwari's uncle has expired, so he has to go. He went
But we can't fix it next week. It will be adjourned for 2 weeks. That is not possible.
2 weeks.
We'll not do it today. We'll do it on such and such date. That kind of prayer we cannot entertain.
Your lordship,
On the prayer of learned counsel for both the sides, this matter stands adjourned for 2 weeks. List accordingly.
no, obliged.
Hearing is for motion item 1, 2, and 3.
May it please your lordship. Lordships, in this matter, yesterday night at around 8 PM, they have released the answer key in the official website. So I failed to take the instructions. So lordship will permit me some time to get the instructions as well as to file and reply to that matter next week. Because
Heard learned counsel for the read petitioners in this batch of petitions. Also heard Mr. T J Mohanto, learned senior counsel assisted by Mr. P P Datta appearing for the APSC, who submits that the final answer key has been released yesterday evening. The petitioners counsel have also confirmed the said fact, but seeks a week's time to
next
obtain
week, my lord, any day.
updated instruction in the matter. In view of the above, let these read petitions be listed again on 26th of May 2023 for motion
My lord,
as fixed items.
my lord. All three?
You keep it.
All three?
All three. All three. You
I'll
give
use-
their names, so and so, so and so, so and so. Mr. S. Burua, Ms. S. Burua, learned government advocate Assam is present on behalf of the state. Common order DD1, so and so for so and so, so and so, so and so, declare.
Item 9.
Updated instruction and file affidavit.
Item 9.
Yes, what is this?
No, this is a matter pertaining to promotion of the petitioner from grade 4 to LDA, my lord. What happened in this matter, my lord? He was in the zone of consideration for promotions, his ACRs were sent. But in the meantime, a new rule came. So they said as per the new rule, the qualification has been changed from higher secondary to graduation. So you are not entitled for promotion. The petitioner along with 10 others approached this honorable court by filing a writ petition. This honorable court directed that the respondents to consider the same, whether the new rule will be applicable or it will be given by the old rule, and also to the to consider whether the vacancies were erode or surfaced after the new rule or before the new rule, and pass necessary order. They have given promotion to all 9 except the petitioner. One of the junior person to the petitioner, he approached this honorable court by filing a writ petition. Look, in that case, this honorable court, considering everything, passed an order to give him promotion, my lord. And
The order is to give him promotion.
he has been given promotion not only to the post of LDA, further promotion also he has got. So primarily, my lord, what I am praying before your lordships is a similar order to the order passed by this honorable court in the case of my junior, my lord. And my promotion
No,
from,
but you say the order of the court is to give him promotion.
yes, two writ petitions, my lord.
Where is that order? Let me
Yes,
see.
my lord, I'll just take it.
Can an order be given to promote someone?
Yes, lordship will kindly appreciate page 63, it starts. This is with respect to the person who are junior to me. May I read me?
Hmm,
Page 64, it starts, Milo.
yes.
The petitioner's case in brief is that as the petitioner is eligible for promotion to the post of judicial administrative assistant, a direction should be issued to the respondents to promote him to the post of JAA as per the Assam Secretariat Subordinate Service Rules 1963, hereinafter referred to as 1963 rules, and the subsequent Assam Subordinate Service Amendment Rule 1999, hereinafter referred to as 99 rules. The petitioner's counsel submit that as the vacancies in the post of JAA occurred prior to the coming into force of the Assam Secretariat Subordinate Service Amendment Rules 2012, hereinafter referred to as 2012 rules, the petitioner should have to be considered for promotion on the basis of rules existing at the time when the vacancies occurred and not as per the amended rules. The petitioner's counsel submit that as the petitioner was appointed as grade 4 employee by the Secretary of the Government of Assam in Public Works Department, the Assam Secretariat PWD would have to consider appointment of the petitioner for promotion to the post of JAA as per 1963 rules and 1999 rules. Now, Lordship will kindly come to para 7, Miller, in the next page.
Yes.
I have heard the Learned Counsel for the parties. The petitioner is serving as grade 4 peon in Assam Secretariat under the PWD Nazrat branch. The 1963 rules provides for promotion of a grade 4 employee to a grade 3 post to the extent of 10% of the vacancies in grade 3 in the year of selection. This writ petition had earlier been disposed of by this court by order dated so-and-so in line with the order dated so-and-so passed in WPC number so-and-so. The relevant portion of the order dated so-and-so passed in WPC so-and-so is reproduced below. In the instant case, it is the case of the petitioners that since there are 9 vacancies again 10% quota earmarked for the category to which the petitioners belong to, before the amendment was brought by notification dated so-and-so, their case is required to be considered as per the pre-amended rules. In this connection, the petitioners have referred to Annexure 6(6)A orders dated so-and-so so-and-so to show that there are vacancies. In fact, by Annexure 7 notice dated so-and-so, the grade 4 employees who had completed 7 years of continuous service as grade 4 and had passed higher secondary and above examination were directed to furnish particulars mentioned in the notice. Thereafter, process was initiated and the petitioners submitted their particulars. However, the selection was not concluded. Thereafter, the aforesaid challenge was made to the amended rules. However, the amended provisions have been upheld by division bench by order dated so-and-so. From the above narration of facts, the basic issue which has arisen for consideration is that as to whether the vacancies which were existing prior to the amendment brought by notification dated so-and-so are required to be filled up as per the pre-amended rules. Another issue which requires consideration is that as to whether the respondents were obliged to hold selection every year or could have clubbed the vacancies of several years in a single selection. In this connection, Sri so-and-so Learned Counsel for the petitioner has also referred to the decision reported in so-and-so, in which it was held that the norms of rules as existing on date when process of selection begins will control such selection, and any alteration to such norm would not affect the continuing process unless specifically the same were given retrospective effect. In the instant case, the amendment was brought on 19/10/2012, clearly stipulating that such amendment would come into force on the date of their publication on the official gazette. The official gazette is dated so-and-so. Thus, the amended provision came into effect from the said date. According to the petitioners, vacancies were existing prior to the said amendment, so they have specified the number of vacancies as 9. In the counter affidavit filed by the respondents, in this aspect of the matter has not been denied. However, the stand taken is that since the rules has already been amended, the said amended provision would apply to the selection. In view of above, the writ petition is disposed of directing the respondents to consider the following: whether in view of the fact that the vacancies in question have fallen vacant prior to the amendment brought on 19/2010/2012, the same would be governed by the pre-amended rules, whether the respondents were required to hold the selection every year or could club the vacancies in a single selection, depending upon the outcome of the consideration of the case in the above manner, the further course of action will be undertaken. Subsequent to the above disposal of the writ petition by order dated so-and-so, a review petition was filed by the state of Assam contending that though the petitioner had been serving as peon in the office of PWD Nazrat branch situated within the Assam Secretariat complex, the petitioner was not under administrative control of the Secretariat Administrative Department, and that the appropriate authority was only the PWD. This is the reason, Millard, basing on which my case was also rejected, Millard. Same reason assigned. Thereafter, this court allowed the review petition by order dated so-and-so on the ground that PWD had not been a party earlier, and they should be accordingly made a party in the present case. Thereafter, PWD was implemented as respondent number 4 and 5 by order dated so-and-so passed in IS so-and-so. In affidavit in opposition filed by the respondent number 5, states in para 4 as follows: that with regard to the statements made in paragraph 10 of the writ petition, the deponent begs to state that the petitioner was appointed as grade 4 by the Secretary to the Government of Assam in PWD Assam Secretariat and is presently serving as grade 4 peon in PWD Nazrat branch, and the office is situated within the Assam Secretariat complex. But for promotion for grade 4 to grade 2, junior administrative assistant, Assam Secretariat Subordinate Service Rules 1963 is applicable. The deponent further states that when vacancies arise in the cadre of grade 3, Secretariat Administration Nazarat Department issued notice to all technical departments and other departments under Assam Secretariat to send the names and the other required information of eligible grade 4 employees to SA Nazarat. Moreover, Secretariat Administration Nazarat Department requests the concerned departments to furnish ACR special reports in respect of grade 4 staff serving under the administrative control of the concerned department for promotion to grade 3 junior administrative assistant. After observing all necessary formalities, SA Establishment Department issues promotion order from grade 4 to grade 3, including eligible candidates from PWD also. In view of the stand taken by the state respondents, that the promotion of the petitioner from grade 4 to the post of JAA will have to be done by the Secretary Administration Nazarat Department, and that the 1963 rules will be applicable for considering the promotion of the petitioner. The Secretariat Administration Nazarat Department is directed to consider the promotion of the petitioner from grade 4 to grade 3 JAA post as per 1963 rules and 1999 rules, as the vacancies occurred before 2012 rules came into force. The same would be done within a period of 2 months from the date of receipt of the certified copy of the order. In the event it is found that the juniors of the petitioner have already been promoted, the state respondents shall promote the petitioner with effect from the date of which juniors have been promoted. Pursuant to
So you are not correct when you
I'm sorry.
said give.
consider for promotion. I understand.
No,
There is no mandamus.
no direction like that.
I'm sorry, my lord. There was a direction for consideration of his case for promotion, my lord, for from grade 4 to grade 3. After this order, my lord, this person,
Not cannot. High Court will not issue a direction like this
true, my lord.
unless proper case is made out to issue such a direction.
The
Otherwise, the
compelling
direction
situation-
is always for consideration.
Yes, compelling situation has to be there, then only the High Court. After this order, my lord, this
So this
person-
order was passed in a case filed by the junior of the petitioner.
Yes, my lord. Subsequently,
Then why was he a party? He was not considered? When the petitioner in WPC 564/2015 was considered for promotion,
yes,
your client was not considered?
no.
Why?
My lord, because, my lord, what happened, lordships, I have read the paragraphs of the earlier order passed by this honorable court, wherein this honorable court directed to consider the case of the petitioner on 2 parameters, whether vacancies arose prior to that date. In that writ petition, the petitioner was a party. He filed the writ petition. Others that your lordship will find, that order, your lordships, I have annexed that order. Page 51. Page
51.
51, there were 9 petitioners.
Hmm.
The present petitioner before your lordships, he was at serial number 9. Dinesh Kumar Singh.
Mhm.
So they initially filed this writ petition, and this honorable court directed at page 55, 2 directions, whether the vacancies in question were occurred prior to amendment or not, whether they can fill up the vacancies by clubbing up or not. These two directions were issued for consideration of the respondents below. They considered out of this 9, 8 they gave promotion. They left me on the ground that I don't belong to SAD department. I am a employee of Milord Water Resource Department. Same in the case of Milord, this second order, the second writ petition, Gajendra Kumar Roy, that your lordship has just read, I have read at page 63.
Hmm.
His case was rejected also on the same ground that he belonged to PWD department. So his case cannot be brought under the rules of 1963. Subordinate Service Rules 1963.
Yes.
Then PWD was made a party. PWD filed affidavit. PWD clarified everything. That although he was appointed by the PWD, but for all practical purpose, that office is situated in the SAD department, and promotion from grade 3 to grade 4 to grade 3 posts are considered within the purview of the Subordinate Service Rules 1963. So in that view of the matter, this honorable court directed that consider his case for promotion to grade 3 in view of that stand of the PWD. Now, similar reason has been assigned in my case also, saying that I belong to Water Resource Department. We cannot give you promotion. You are out of SAD or GAD now, my lord. So in that context, they have given promotion to this Gajendra Kumar Roy also. That your lordship will find page 69. And page 69, 11 September 2019.
Yes.
This was issued by Commissioner and Secretary, Secretary Administration Department in compliance of Honorable High Court's order dated so-and-so in WPC so-and-so and order dated so-and-so in past and contempt case number so-and-so, so-and-so, PW Department is promoted temporarily to officiate as Junior Administrative Assistant under Rule 83 of Assam Secretariat Subordinate Service Rules 1963 as amended in the pay band of so-and-so per month with retrospective effect from the date on which his immediate junior was promoted and posted in Political A Department. And the factum that this person, Gajendra Kumar Roy, was junior to me, that you also will find from page 38. When the promotion process was undertaken, the SAD Department Administrative Officer wrote a letter, page 38, you'll also will see, subject promotion from grade 4 employees to the post of JAA. In inviting a reference to your letter on the subject cited above, I am directed to furnish names of 44 numbers of grade 4 employees who have fulfilled the eligibility criteria for promotion to next level. Accordingly, a statement showing their names as per their seniority, date of joining, educational qualifications, etc., along with ACR's consecutive 3 years are enclosed herewith for necessary action. In the next page, Lordship will find this is the list sent by the department. The petitioner is at serial number second last, my lord, Dinesh Kumar Singh. This list was prepared in accordance with seniority, my lord. Second last person, Dinesh Kumar Singh, and the person who got the promotion is in the next page, serial number 1.
So he is seeking promotion to which post now?
Grade 3 post, JAA. JAA, Junior Administrative Assistant. Now it has been.
But this list is of Junior Administrative Assistant only. Junior Administrative Assistant is grade 3 or grade 4
No,
post?
the grade 3 post.
Look at page 39, what does it say?
List of eligible grade 4 employees for the post of Junior Administrative Assistant.
Achha, this is list of candidates for promotion to.
Yes, yes. The previous letter says, my lord, the page 38 letter clarifies that the names are given in accordance with seniority, date of joining, education qualification for the purpose of promotion.
So the dispute is his terms and conditions of service will be governed by which rule?
Yes,
That is the dispute here.
yes, that is the dispute.
What does the department say?
Department say that I work in Water Resource Department, so they cannot consider my case. Meaning thereby, I don't come under the purview of the Subordinate Service Rules 1963.
And what does Water Resources Department say?
My lord, Water Resource Department, there is no stand as of now by the Water Resource Department. But,
Yes.
but going by the same stand, the reasons for rejection, PWD in the case of Gajendra Roy also, they said you are an employee of PWD. We cannot consider that order. I have annexed, my lord. If your lordships kindly see, that page 70, my lord. Page 70. Promotion to the cadre of JAA. It was addressed to Gajendra Kumar Roy. Secretary Administration established a department has taken necessary follow-up action to comply with the Honorable High Court's order dated so and so in Kishore Lokar and others and WPC number so and so, Gajendra Kumar Roy, State of Assam. A copy of speaking order in this regard bearing number so and so is enclosed for your reference. Further, please be informed that your petition could not be considered as you are not appointed by SA Nazrat department. It was said since he was not appointed.
So according to you, the petitioner is governed by which set of rules?
1960 Subordinate Service Rules 1963.
All right, substantiate that.
Yes.
Yes. Where is the rules of 1960?
Yes, page 16, my lord.
Yes.
Lordship will first come to page 17. Definition, secretariat. Secretariat means,
Just 1 second.
I'm sorry.
Yes.
Definition, your lordship will find secretary. Secretary means all departments of the government secretariat, including chief minister's secretariat and public work department secretariat. Then your lordship will kindly come, public work department secretariat is included under this rule. Then my lord will come page 19. Rule 8.
Rule 8, yes.
Yes, rule 8.
Yes,
Lower
please.
division assistant. The appointment
Yes,
to the
yes,
post of
yes.
lower division. Appointment to the post of lower division assistant shall be made by direct recruitment on the basis of competitive examination and an interview as per schedule 2. Then in the next page, lordship will kindly take 8.3 rule. By selection from among grade 4 staff and record suppliers of the secretariat who have passed the matriculation examination or high school leaving certificate examination or higher secondary or equivalent examination and have rendered at least 7 years continuous service in the secretariat on the first day of the year in which selection, was made. I fall in this category, my lord. 8.3. From among grade 4 staff and record suppliers of the secretariat.
This is by selection, not promotion.
Yes, rule 8.3 is by, yes, by selection from eligible grade 4 post. Whatever process they undertake, that is, they have to follow.
No, Mr. Das, don't mix up things.
My-
You are just moving into a very difficult territory for you.
Yes,
Selection, you want promotion.
yes,
Selection is not promotion. If you say you come under 8.3, where is the
yes.
question of promotion?
If your lordships kindly come to down below, note the proportion of vacancies to be filled in year according to sub rule 1, 2, 3 above shall be 60, 30, 10 respectively. This means that recruitment of lower division assistant will be 60% by direct recruitment, 30% by promotion from eligible typist by selection and 10% by selection from among grade 4 staff and record suppliers. So 10% quota is fixed.
That's not the point. What is the process of intake in respect of the 10%? That's what I'm asking. What is the process?
Process they follow is they call for the ACRs, consider
First,
them.
what is it, promotion or recruitment by selection or direct recruitment? What is the process?
This is, so far my understanding goes, this is promotion.
Understanding means then it has to be interpreted. That
This
means
is-
there is no case which covers your case.
That is how they have done, my lord. That is how they have done. They have called for the
Oh,
ACRs.
Mr. Das,
I understand.
what they have done is binding on the court.
No, absolutely not. Lord,
Court will have to either follow a precedent
Yes,
or lay down the law. There is no other way out.
no other.
So is your case covered under any precedent of the court passed earlier? What is required is clarity.
True.
When you are arguing a case as a counsel also, first thing, always ask yourself, do you have the clarity in what you are trying to project and why you are trying to project? Because that is what helps us decide cases faster. If you make arguments which are this way, that way, then we'll hear and post it on another day. That's the only way out. I am asking you, what is that your client is seeking in this case? What has happened in the past, as I always said, only the ratio of a previous decision is binding on this court.
True.
Apart from that, no other, nothing else is binding. And I am ready to put it down in, I will only follow the law laid down.
True.
What has been done in which case, on what facts, I cannot reopen that. So all I'm asking you is, you are seeking promotion. So first you have to tell me, promotion is a creature of rules, correct? Without the rules, there can be no promotion.
No promotion.
That's a settled law. So you have to tell me that, see, this is the promotion criteria. This is the zone of consideration. I come within this zone for this
Yes.
reason,
Yes.
but my case has not been considered. So please issue a direction to consider my case.
True, my lord.
And if I succeed, my seniority position should be ahead of my junior. That can be your case,
Yes,
which is what I thought you started with.
it is.
But then
it is.
where is the promotion procedure? There is no promotion, scope of promotion under the rules. If you say you are covered under 1963 rules,
Yes,
then there is no scope for promotion.
it says about selection, my lord.
Yes.
It's selection from among grade 4 staff and record suppliers of the secretariat who have passed
Correct. So
matriculation.
therefore, are you not contradicting your case on the face of it? It's turn turtle.
Is because if your lordships kindly see the page 38 for a moment, under the rules.
Do you think you are confident to argue this case, or you need to have a relook at your strategy and your issues? It is up to you. I will hear you and pass a judgment. But it
I'll-
seems you are not very clear what you are asking for.
The rules are, my lord, a little bit. Because
No, no,
rules
can
say
be anything,
selection,
but
rules are.
you are the
rules say
counsel,
selection.
you have to have a clear stand.
I understand, because rules say in the 8.3, rules say selection. But what the process, the respondents in the case of
You
other.
have to make an argument, Mr. Das.
True, my lord.
You can't say this is hazy, so give me something.
No, no, no,
That is not possible.
that is not possible.
So you have to give me a clearly established case on clearly established principle. We'll ask them for answer. If they can't answer, we'll issue a mandamus. This is a matter of 15 minutes.
True.
But you started your case. I was about to dictate the judgment. But your case is not of promotion. If you rely on the rule, no promotion. If you don't rely on the rule, no case. So you'll be going round and round and round. You better
I'll
relook,
go through it.
re-strategize and
Yes, my lord.
make up your mind what you want to ask for. And
I'll go
previous
through it.
orders rely only if it lays down a binding precedent. It must, the ratio is only binding, nothing
Yes.
else.
Nothing else.
If there is a ratio, what is a ratio? Ratio is the reasoning,
Reasons assigned.
reasoning for the decision. That reasoning once given by a previous court, coordinate bench is binding on it. Nothing else is binding.
True.
X, Y, Z, so give him promotion, that is not binding.
No.
That is up to the government to comply with and take steps. But what is your stand then? What is
I'll
it?
go through the rule.
But anyways, I'll
I'll
help you a little
reconcile.
bit. Mr. Goswami,
Yes,
you have been trying to
Lordship
say
has-
something. What is
No, my
this
lord.
happening?
Since he will make his submission.
No,
on
he will
this
make
point.
his submission, but you are the department.
Department, my lord, my learned friend representing the competent authority of the secretariat, he will make submission and our submission will be one and
No, but
same. Even
the
same.
court wants to
Since-
know,
My lord.
this man has been working in a great.
Yes. That is correct. That is correct.
Are you saying somebody is saying he is not a part of secretariat, the department is saying he is not a part of us?
My-
What is this? Somebody is wrong.
My-
You decide who is
Right.
wrong. Both of you can't be correct.
My-
He is in service.
Yes, he's
Water resources says he is not our employee. Secretariat says he is not our employee.
employee, that is not disputed. My lord.
Hmm.
So far employment is concerned, so far continuity in service is concerned, that is not disputed.
So then either of the two departments will have to consider his grievance.
Right.
Who will do it?
Secretariat administration and
Do
now.
you agree with that?
JD. my lord.
Lordship, I'm limiting the scope of this discussion, Lordship.
Yes.
Lordship will kindly see the prayer. Only the prayer, Lord.
All right. But this man cannot be left remediless.
Lordship. Lordship will see the prayer, only prayer, Lord.
Hmm.
Fifth line, Lordship, to consider the promotion of the petitioner as junior administrative assistant from the post of grade 4 in the vacant post arose before the amendment of Rule 2012 notified on 19/10/2012.
Hmm.
2012, Lordship, was an amendment wherein the educational qualification was enhanced to graduation. So by this prayer, Lordship, he is saying, don't apply 2012 in my case so far as the educational qualification is concerned. That is his prayer.
Mr. Nayak, we will come to these things later. He has made this prayer because at that point of time, he had a particular judgment in his eyes. And he thought, I will write this judgment and get an order, probably. He means I'm not referring to Mr. Das, but he understands who I'm referring to. You tell us one thing. What is the remedy for this man? He has been left high and dry without a promotion. Both the departments are disowning him. Both of them can't be correct.
No. Suppose I own him too, Lordship, either me or the Water Resource Department, except whatever is his contention, he is entitled for promotion. Minus that qualification, Lordship, can he be promoted?
Which qualification?
Graduation.
But it is higher secondary HSLC,
At that point of time, Lordship.
right?
Since from 2012, it's graduation. So
That's
if-
right. So his case is his junior was promoted against a vacancy which arose prior to 2012.
at that point of time, that was the law, Lordship, Rangaya judgment. Now that has been overruled now, Lordship.
Hmm. What is the judgment now?
Now, latest judgment is Lordship, two judgment, Lordship. One is very recent, Lordship, it was. One is state of, it is 2022 SCC online, SC 680. It's state of Himachal Pradesh versus Rajkumar, Lordship, that is one.
Hmm.
And the latest one is, Lordship, state of Uttar Pradesh versus Rasna Hills, Lordship. It is by Honorable Chief Justice, Lordship.
Yes. What does it hold?
Lordship, it says the rule prevailing on the date of consideration will regulate the conditions of service, Lordship. So if I consider his,
That will normally, but what happens if erroneously a consideration is not made?
it was not done erroneously, Lordship.
Hmm.
At that point of time, also his case was considered
Hmm.
because two posts were lying vacant at that point of time.
Hmm.
And those two posts were, it was STP Hills, Lordship.
No, but this man, you promoted someone.
Those two posts will not later on de-reserve, and against that, this Gajendra Kumar Roy was promoted.
How was this man promoted? Age 70?
Lordship, at that point of
There
time, one
affidavit
contempt
is-
case was there, Lordship. That was the compulsion before the authority, Lordship. And at that point of time itself, Lordship, authority.
So there can be a similar compulsion once again? If that is the stand?
In this case, Lordship, I would try to
Compulsions can,
definitely persuade your Lordship.
huh?
In this case, I would like to,
Court passes an order, there is a contempt case.
that
Give
will
up your
be
stand.
obligatory for us, Lordship. If your Lordship directs Lordship, then we will definitely comply.
If that is the submission, then
Lordship.
there is nothing else.
But
Then we
Lordship,
can close the matter today. Hmm?
But before that, Lordship, I will definitely try to convince your Lordship not to
No,
pass it.
no, Mr. Nayak, you see, the department stands are always well appreciated by the court. But sometimes stands are taken where it on the face of the matter, it shows extreme hardship to a candidate. No? Everybody above him, below him gets promotion. He is the only one who is left high and dry. And what is the reason? That when the rules were there, he was not
No,
considered.
he is not, today, Lordship, he is not the only candidate, Lordship. There are many persons, Lordship, in the cadre of grade 4 and record supplier, Lordship. They are not getting promotion only because of the educational qualification, Lordship. He is not the only one, Lordship.
So Mr. Das, you have to labor a little bit then.
Yes,
That is-
I understand, but for my satisfaction, if
These are not unsurmountable issues.
True,
But
ma'am.
you have to, the only order of learned single judge, if that was the only thing you are relying upon,
Lordship.
that will not be sufficient.
In fact, just for my satisfaction, I'm referring to
Hmm.
page 52, if your lordship see the first order of this honorable court. This honorable court went by the premise, the petitions numbering 9 are aspirants for promotion to grade to the post of junior administrative assistant. Presently, they are grade 4 cadre. That is my.
Mr. Das,
I am-
tell me the law,
And
tell me the law. What is the law? Give me a legal answer.
true, my.
What has happened in the past,
In
that's
fact,
not going to help you.
in their affidavit also,
Hmm.
they are considering this to be a promotion.
Whatever it is, you show me that these are the facts and this is the law. And therefore you are entitled to amend them. We'll ask
I'll
them.
come up, my lord. I'll
If you
satisfy.
can
you.
do it today, you argue.
I'll satisfy, my lord. I'll just go through the rules and I'll just deliver it.
Have
on
you
the
taken
lordship.
note of
Wait.
these judgments?
Yes, I know, my lord. That judgments will not be applicable in this case, my lord.
Why?
The reason is that, my lord, whether regarding the entitlement of the petitioner for consideration of his case,
Hmm.
that, my lord, has already been settled by this honorable court in the judgment and order dated, my lord, 2019. 27/11/2014. This honorable court settled that he is entitled for consideration under the particular rule. They have considered all 9, they have considered. Subsequently, as because the law, separate law has come, the already the issue which has been settled past, that cannot be reopened, my lord. That cannot be reopened. That is not the legal position, my lord. Tomorrow, another judgment will come, which will, my lord, overrule this Rajkumar judgment also. Then the issue which has been settled as of now, whether that will-
These are not correct submissions. It is not like that. There is a procedure which is followed in these matters.
that is what,
Tomorrow another judgment may come. But the judgments, when they overrule the previous judgment, there is a method in this. You can't
yes.
say that even if a judgment comes, it should not be.
What I am trying to know, I am not saying that it should not be followed. What I am trying to submit is that, my lord, since the issue has been settled, 9 persons you have considered in terms of the previous rule.
Wrongly considered. So it should be done in your case also.
At that point of time, that was the right consideration. my lord.
Maybe, but in this point of time, if it is shown to be wrong, what I am saying is you show your entitlement under the rule. There is no negative equity.
I understand, my lord.
If you don't succeed in showing how your claim is to be accepted by the court, we will not accept it.
That I'll satisfy so far as rule is concerned,
You
my
want
lord.
to do it today?
Not today, my lord, some other day.
All right.
I'll
I
say
heard Mr. H.K. Das, one council of planning for the Commissioner. Also heard Mr. B.
Yeah.
Swami.
one
Please.
One prayer, my lord. Till date, the water resource department has not clarified their stand in affidavit.
They
Although
have accepted your stand.
they
We'll
have-
make it clear.
Yes,
No affidavit means stand accepted.
yes, my lord. That I am an employee of the SAD.
My respectful submission is, my lord, we will rely on the submission of the, my lord.
No, I'm not saying.
No, you rely, but you have accepted his stand.
No, my lord, my lord, because we have no conflict in between two departments, my lord. That is why. they
No,
have
what I'm
submitted affidavit, my lord.
What I'm
They have,
submitting
they
is
have,
that
they have filed affidavit, my lord, General Administration Department, we rely on them.
whom I belong to.
Because
my
inter
query.
conflict will not do, my lord. Will not help anyone, my lord.
Whom
Inter department.
whom you belong to is not the legal issue. It is a rhetorical issue.
That is,
The question is which rules govern your
Yes.
that
service.
I'll satisfy, my lord, but whom I belong to, that is the reason why they have rejected my case. That's why I am asking.
All right.
So the additional
So
advocate
there
general
was
made a
some-
submission.
And an additional AG also said by Mr. P. Kotakis, Learned Counsel for the Water Resources Department. So
One
Mr. P. Nayak, that is respondent numbers 1, 2, and 3.
I'm
The
waiting for,
P9 Learned Standing Council, PWD Assam. is-
GAD Lordship.
Learned Standing Council, GAD Assam has appeared for. Respondent number,
1 minute, Lordship.
Yes.
Lordship, 4, 5, 6, and 7, Lord.
respondent numbers 4, 5, 6, and 7. On the request of Mr. Das, admission hearing of this matter stands postponed till. Further admission hearing of this matter stands postponed till. We'll have it on 6th of June.
My lord.
6th of June 2022. So as to enable Mr. Das to examine certain legal issues and address this court. List the matter accordingly. Yes.
I'm highly.
That is a motion. Here, my lord, page 45, my lord, annexure 7 is under challenge, my lord. So there is a provision under the, my lord, Air Force Act, my lord, under section 92. Impugn.
Yes, what is under challenge?
Your lordship at page 45, annexure 7, my lord. The 46 was 45 was 7.
Grant of maintenance allowance.
Yes, my lord. But there is a provision under section 92 of the Indian Air Force Act, my lord, where, my lord, if the wife, my lord, or even the mother, my lord, he applies for grant of maintenance from the husband or the son, my lord, then he is entitled to maintenance, my lord. And in fact, my lord, there is a procedure laid down, which I'll relay later on, my lord, under the Air Force order, my lord, whereby, my lord, the certain guidelines are framed, my lord, by which, my lord, the amount has to be calculated and disbursed, my lord, directly from the salary of the, my lord, airman concerned, my lord. So what has happened, my lord, here, the procedure, my lord, firstly not laid down, my lord, and secondly, the quantum, my lord, is on the higher side. So, my lord, that
You are
is,
for whom?
I am for the husband.
Hmm.
Basically, my lord, the marriage was solemnized in 2018, my lord, and my lord, dispute started, my lord, from October 2019. My lord, here the day on 18 to 2018, my lord, the marriage was, my lord, solemnized. Dispute started, my lord, with effect from October 2019, my lord. Now, my lord, she is otherwise qualified, but she has admitted, my lord, that she is highly qualified, my lord. Initially, she was, my lord, working in the Vinayak furnishing, my lord. She is originally from Dhekkeoje, but presently, my lord, working at Vinayak furnishing prior to her marriage, my lord.
Hmm.
My lord, therefore, my lord, lordship is aware, my lord, when we are shifted to our airbase, my lord, certain restrictions are there, my lord, the family members are not allowed. Subsequently, even she was allowed to be taken, my lord, we resided together. But because of various, my lord, problems, my lord, disputes arose. Now, thereafter, my lord, in the month of October 2020, my lord, they came down during the COVID times, my lord, they came down to Dhekkeoje, my lord. They stayed in a hotel because of the quarantine requirement, my lord. They were in a hotel, my lord. She wanted to go back to her matrimonial place. She was forbidden, my lord. She lost an FIR. So those things were there, my lord. Now, lordship, thereafter, my lord, she filed an application. My lord, in fact, as per requirement, we are required to inform the authorities when there is a marital discord between the parties. That is the requirement under the, my lord, law, my lord. So, my lord, I informed. My lord, we were counsel. My lord, ultimately, she said that I will not grant because I will also not stay with him. That is the stand of the wife. And subsequently, my lord, an application was filed seeking grant of maintenance under section 92 of the Air Force Act. And this was the impugned order passed. Now, lordship, if your lordship kindly come to page 46.
Yes.
It's a very summarily this order was passed, my lord. I'll refer to paragraph 4.
Yes.
And whereas the case has been examined, and I am of the view that it is a fit case for grant of maintenance allowance to the wife of the said air warrior on account of the following reasons. Number, it is clearly evident that the facts of the case that the lady was compelled by the circumstance to stay away from the matrimonial home. The matrimonial disharmony exists between the parties to the extent that both have filed cases against each other. that the husband is under a social and legal obligation to maintain his wife and with due care and respect. He has neglected his wife and not providing any financial support to her. The lady has no source of income for her survival. The employability of the lady before her marriage or after her marriage till the time she stayed with her husband has no merit to debar the lady from her claim of maintenance allowance. There is no chance of reconciliation. Now, therefore, after considering the entire case and is in excess of powers vested in me under section 92(1) of the Air Force Act 1950, read with section 160 of the Air Force Rules 1969, I hereby order that 13,800 be paid every month from the pay and allowances so and so with effect from the date of application of the lady, that is 12th of January 21, payable on last working day of each month to Sri Munmun Boni as maintenance allowance to the wife for a period of 5 years at a time or till renewal or divorce or grant of maintenance allowance by a civil court or discharge retirement of the individual subject to AF Act 1950 or material changes in facts and circumstances which was earlier. Now, Lordship, I'll just take you to the Milord procedure which is required, Milord. That your Lordship will find at page 48 and Annexure 8, Milord. 49, Milord, that it.
Yes.
Now, I'll just take you to Milord first. Lordship may skip, Milord. This is clause 4C, Milord. After receiving the request from the petitioner for grant of maintenance allowance, the AOC STR so and so is to interview the individual concerned, hand over a copy of the application against him and impress upon him his social and legal obligation to maintain his wife and children. He is also to be told that such an obligation continues until the family is either legally annulled or a divorce is granted by the court. The obligation in respect of the children continues until they are in a position to support themselves. The commanding officer is also to explain that any false statement made by the individual in this connection would render him liable for disciplinary action. While acknowledging the request of the wife, where possible, she is also to be interviewed, counseled by the AOC's so and so of the husband's unit, and information may be obtained whether she is employed or if so, the details of her emoluments. The wife will also be asked to intimate details of any independent source of income and immovable property which she may possess, any income therefrom. Details of wife children will be checked, confirmed from the appropriate authority. If the commanding officer is of the opinion that a reconciliation is not feasible and the individual declines to maintain his wife and illegitimate children or petitioner denies to stay with him, he will be served with a show cause notice asking him to explain as to why maintenance allowance should not be granted to the applicant under section 91 so and so as the case may be. The CO, after satisfying himself as laid down in subparagraph 4B above, is to recommend whether the deductions towards grant of maintenance allowance should or should not be made from the pay and allowances of the individual along with justification. So Lordship may skip this part, Milord. Now, Lordship may kindly come to page 51, clause 6, Milord. In cases where it's established that the wife is living in adultery, or if without sufficient reason she refuses to live with her husband, she should be advised to take recourse to a court of law and should not normally be granted maintenance of the competent authority. So this I will refer to, Milord, because she stated that she is not willing to stay with me, neither divorce me, Milord. Now, Lordship will kindly come to clause 8, Milord. While making recommendation for the grant of maintenance allowance, the legitimate financial commitments and the income of the individual are to be taken into account. The quantum of maintenance allowance recommended is to be considered in the light of the following. The amount sanctioned will not be more than 1/3 of the pay allowances for the legally wedded wife and illegitimate children. 1/4 of the pay and allowances in respect of the legally wedded wife alone or legitimate children when only either of them is to be granted maintenance allowance. So, Milord, it is said 1/4. Now, Milord, for the purpose of subpara A above the expression pay and allowances include all sums payable to a person in respect of his service under the provisions of the pay and allowance regulations after minimum or mandatory reductions on amount of income tax provident for DSO PB subscription if the wife children are the nominees, PLI GIS premium if the wife children are the nominees, and the family assistance scheme or any mandatory subscription reductions. Any sum paid directly by the person to the PLI LIC of India, other insurance companies in respect of the policies on his life will also be similarly deducted from the pay and allowances of the person, provided the amount of the policy would be payable to his wife, children on maturity, or the policy becoming a claim prior to maturity. The owners of claiming deductions in respect of the payments made directly to so and so, other will lie with the person concerned who would have been would have to just justify the commanding officer that the children, children are claimed and the policies are kept alive and unencumbered. My lord, so this is the requirement, my lord. My lord, the statutory reductions are to be made. And thereafter the amount is to be calculated, my lord, and the amount has to be 1/4 of the pay, my lord. Now, what they did is, my lord, the requirement is, my lord, there should be counsel and a reasonable, ultimately, my lord, reasonable opportunity should be given, my lord, to place my case. Nothing was done, my lord. My lord, prior to that, my lord, initially, my lord, after the marital discord, my lord, they were counsel. Those things were taken into account, my lord, and the order was passed. Now, the funny thing is, my lord, your
What is the
lordship
issue
kindly,
now? What is the issue here?
now lordship will see. I'll just take you to, my lord, page 99, my lord.
What is the issue in
No.
this petition?
The only thing, my lord, my lord, there is no other way of, my lord, challenging this, my lord, firstly. Now, lordship, what has happened, my lord, because of this, my lord, the deductions were made of 13,800, my lord. At that point of time, my lord, I had dependents. My father was a chronic kidney patient, my lord. My mother was there. My father is expired as of now. My mother was there, my lord. I have dependent sisters. Now, lordship, at last paragraph, last page, my lord, lordship will see this, the maintenance allowance was 13,800, my lord, whereas I was receiving an amount of 8,970, my lord.
Why it can be maximum 1/4 of your total?
Exactly, my lord. Now, lordship will say that direction said, that is the statement is there, my lord. So if your lordship sees exactly, the gross, my lord, 65,800, 800, my lord, 8. The deduction is 28,091, my lord. If your lordship that is calculated from the last page, my lord, then the, my lord, net salary will be 37,717. Now, lordship, if it is 1/4, the amount comes to 9,429. Now, lordship, here is a situation, my lord, where the wife is getting more maintenance, whereas, my lord, I have dependents.
So is there a stay order?
No, it's actually, in fact, initially, the court was of the view that the stay order was to be granted, my lord. The CJC had taken time at that point of time, my lord. And my lord, ultimately, they appeared, my lord, now this is the present, but the deductions is being made at the rate of 13,800 as on date, my lord. And my lord, in fact, number of litigants there, my lord, I had filed a divorce application, my lord, that is pending. Maintenance application is also pending, my lord. The only thing, my lord,
You have filed divorce where?
in Tezpur, my lord. Sorry.
And that has been contested.
They contested.
Who is appearing for the wife?
But they have agitated here 2 points, my lord, but none of them is applicable here because they are said that they are not given opportunity to being heard, my lord. Your lordship will kindly read out the order.
We'll come to that later on.
My lord.
What is the stand of your client? She wants to live with the petitioner or doesn't
My
want?
client, they want to, I'll leave the order is there, my lord. The consolation was held in their department. Mona, she wants to say to sorry and go to him, but the husband did not agree, my lord. Thereafter, he has filed a divorce petition before the district judge Tezpur, my lord.
So wife wants to live with the husband.
My lord.
No.
Wife wants to live with the husband.
Yes, she wants to live with the husband, my lord, but he did not agree. That is why he has filed a divorce case. Before
And what is your client stand, Mr. Day?
she has filed a.
No, my lord, here, if your lordship kindly comes page 31, my lord. In before, at the time of counseling, my lord, sorry, in the application itself, application by the wife, at paragraph 5, my lord, page 31. My parents and leaders tried their best to
Mr. Day,
reconcile, lordship.
You forget your petition. I'm
No,
not
my lord.
interested in
I'm
this.
not agreeable to live with her, my lord, because, my lord, we have been subjected to, my lord, tremendous
So
cruelty,
what I'm saying is,
lordship.
is it a fit case where some mediation should be tried out and if the parties can resolve the dispute? Ultimately, it is a matrimonial dispute.
We tried, madam.
At the end of the day,
We tried.
you cannot try. You are not mediator.
Yes.
Your job is to fly aircrafts,
Yes, yes.
not to do mediation. Your trying is of no good to us.
Here, my lord,
If we go for mediation,
as per
we
provision of
will
Air Force
subject the
Act.
parties to the mediation center.
One chance could be taken, my lord. Only thing, my lord, even when my father died, my lord, she was informed she did not turn up, my lord. So those things are there. my
That's
lord.
all right.
But-
These
but-
hard burnings are there.
Understand.
But at the end of the day, this is a matrimonial
Exactly,
dispute.
exactly, my
Yes.
Unless the matrimonial dispute is settled this way or that way,
lord. Sure.
you cannot get out of it.
True.
You don't get an order, you will go to the higher forum. You get an order, the other side will go to the higher forum. This will continue. This will continue. So that at the end of the day, the real dispute has to be addressed. So you can choose the path of a long and arduous litigation, which will see ups and downs.
In
You
fact,
cannot
my lord,
see.
considering the number of litigations filed, my lord, I am posted somewhere, my lord, and the litigations are pending here, my lord.
Hmm.
Every time I need to come down, my lord, lordship is aware, my lord, how, my lord, below the.
Where are you posted now?
Gujarat, my lord, Gujarat. Now, every time, my lord, be it maintenance, my lord, be it the river proceeding, my lord, I am required to come down. Leave problems are there. Lots of, on top of that, my lord, the amount is on the higher side, because of that, the rules doesn't say, my lord.
So at the moment, you are only interested in this order, nothing else.
No, if the mediation, my lord, we are willing, my lord. It's not that we intend to.
No, don't hesitate to tell me what you.
No,
If
exactly.
you
My
say
lord.
that-
My lord, the amount is on the higher side. That is what is, my lord, one problem, my lord.
Hmm.
Because the lordship is seen.
No, if we go into this, then we'll not go into anything else. Either we'll accept your claim and allow the petition or dismiss it.
True, my lord. So, one mediation can be given, my lord. I am not opposed to that. But that is what I am saying. Only thing, my lord, now the problem is initially the court was inclined to stay, my lord.
Hmm.
But because of the time taken, my lord, if your lordship this is
So
the
your
earlier order.
client is required to come and appear in Assam.
Yes, my lord.
When is the next date?
29th of this month. 29th of May, my lord.
And is your client open to mediation? Mr. Sharma?
I will have to ask her. I have to apply instruction from her. What does she will?
Obtain instruction, then
Because my lord in.
if he comes on 29th, we'll have the mediation proceeding on
That can be-
28th. On 28th maybe.
No, ultimately, nothing will be because considering the number of litigations pending, my lord.
No.
Both of them are.
Mr. They-
And understand.
You are the 1,50,000 council to give these submissions. They are not interested, whether nothing will happen or not. Your
No, because
opinion.
if the matter is certainly mediation, my lord, we are.
Only question is both the parties willing to give mediation a chance here? Because if the ultimate matrimonial dispute is sorted out, everything else is taken care of. Or do you want to go piece by piece, bit by bit, and fight it till your client is in short service commission?
No.
What is his retirement age?
65 to 65 minutes. 60 minutes.
60. And he must be where? Around his 40s now?
My lord, 40. Not 21, 37.
So it's a long journey ahead if it goes in a particular way.
No, that is why I said, my lord, if the matter is mediated, my lord, it would be beneficial for us, my lord. In fact, both the parties.
Where is your client is in Assam?
She might that Guwahati, my lord, or it is her maternal uncle house.
Why don't you ask her? Let the parties see, don't put in your,
That if your lordship want to consult that may fix, I inform her to come.
She is presently working in Vinayak Furnishing. In fact, my lord, on the basis of the order was, my lord, on the
Because
basis of the
consultation was
certificate.
held twice. One to Gujarat, but then and other is for test.
see, Mr. Sharma, you can throw heaps of legal arguments, other arguments to complicate matters. But the fact is, both these persons have a future. Do they want to finish their future just by coming to court and getting orders? Or do they want to live a life and enjoy their life in their own way? There is a lot to life than litigations and court orders, is it not?
I'll inform her, my lord.
Tell her to come then, let us see. You ask your client whether he's
Yeah,
okay.
I'm willing, my lord. I will successful.
And let us give it a chance if both sides are agreeable to.
Either way, either below,
Either
either the
ways.
council or below
We'll have it on then next Tuesday, coming Tuesday,
lordship.
coming Tuesday.
I'm not agree with you.
You don't have to come.
Okay.
Heard Mr. R. Dale and counsel for the petitioner, also heard Mr. S.K. Middle and TGC appearing for the respondent, official respondent. Mr. K. Sharma and counsel has appeared on behalf of the respondent number. You have for respond number?
4 my lord.
4 million.
Respond number 4. On the request of learned counsel for both the sides, this matter is directed to be posted again as a fixed item on 23rd of May 2023, so as to enable learned counsel for both the contesting parties to obtain instruction as to whether they would be open to submitting themselves to the process of mediation through the Guwahati High Court Mediation Center, so as to resolve the core dispute, which is nothing but a matrimonial dispute. You can ask your client to come. I'm not passing any order. We'll ask her. See, the idea is bring peace in the life of people. That is the idea.
I'll ask her.
Yes. Sometimes they don't understand many things.
Next,
And when they understand, it is too late.
any that fix,
23rd May,
23rd May.
yes, 23rd May.
My colleague will be there.
Yes, yes.
He will be there.
VIP Lordship. Lordship, the petitioner was retired from service after completion of 30th, my lord. At the time of 30th, my lord, the benefit of third MSCP has not been granted to him. So he has communicated to the department and they have replied that due to the lack of ACR, the benefit has not been granted to him. But that adverse entry has not been communicated to me, my lord. So that's why I am before your lordship, my lord. And in their affidavit, my lord, they have already agreed that the entry has not been communicated to him.
Lordship, it was admitted, but Lordship, the entry which was given, Lordship, it was not below average, Lordship. It was the average, so we have not communicated.
Up to good, it is bad, adverse entry. Up to good. Only very good is not an adverse entry.
Lordship. It was given to average, Lordship.
What to do? Your argument would be, I leave it to the court.
Lordship.
That's because you have not gone through the file.
Lordship, I have done the Lordship. I have para A.
How can you leave it to the court?
Lordship, page 8, we
The
have.
law is very simple.
Lordship.
If you have relied upon adverse entry in the SCR without communicating,
Lordship.
then it is illegality. Already the law is there. Why every time the court has?
My lord, Devdutt is there.
I'm communicating with him. Have the courtesy to take your seat.
Excellent, sorry, madam.
Lordship, our stand was that it was not an adverse entry, Lordship. That's
He has already retired.
retired, Lordship.
So what relief can be granted to him now? He cannot be promoted now.
No, promotion is not, my lord, only the benefit of third MSCP.
Huh?
Only the benefit of third MSCP.
So if he has not been promoted, you consider? Heard Mr. B. Kumar, learned counsel appearing for the writ petitioner. Also heard Mr. S.S. Roy, learned CGC representing the respondents. Full stop. The petitioner herein had retired as Havildar, GD, bracket general duty. On 01/01/2021, while serving under the 43rd Assam Rifle C/O 99 APO. Full stop. While in service, the petitioner's case was not considered for promotion on the grounds that there were adverse entries in his ACR. Full stop. However, according to the petitioner, the authorities could not have relied on uncommunicated adverse entries in the ACR so as to deny him promotion. Full stop.
Benefit of third MACP, my lord, not promotion. Benefit of third MACP.
To benefit him. That's all. However, then you write like this, the petitioner was neither considered for promotion nor was his prayer for grant of third MSCP considered by the authorities. Full stop. According to the petitioner, the respondent authorities would not have relied upon the uncommunicated adverse entries in the SCR so as to deny him the benefit of the third MSCP. Mr. Kumar Service submits that after completion of 30 years of qualifying service in the Assam Rifles, the petitioner had to retire without the benefit of third MSCP, which he was entitled to due to want of promotional avenues. Full stop. By relying upon and referring to the law laid down by the Supreme Court in the case of Devdutt, what is it?
2008 8 SEC.
Devdutt,
My lord.
Devdutt versus so and so, reported in so and so. Give the citation. Why are you giving it?
2008 8 SEC 725, my
Give it, hand it over.
lord.
Mr. Kumar submits that the recourse taken by the authorities in this case is arbitrary and illegal and therefore calls for interference by this court. Full stop. The respondent numbers.
This is the judgment of Sukhdev, my lord, but Devdutt has
You
mentioned.
don't have Devdutt.
It's mentioned in it, my lord.
You check it, Devdutt versus, 2008 8SSC 725. The respondent, this affidavit in opposition is filed by whom?
Lordship, the commandant lordship.
Huh?
He is in charge legals in lordship.
By filing affidavit on behalf of the respondents, it has been admitted that the entries in the form of average in the SCR, the gradings in the form of within course average in the SCR of the petitioner
Page 8, lordship.
was taken into consideration so as to deny him the benefit of third MSCP, but such adverse entry was not communicated to the petitioner. Full stop. If that be so, there can be no doubt about the fact that after the law laid down by the Supreme Court in the case of Devdutt Supra, as well as Sukhdev Singh versus Union of India and others, reported in 2013 close 9 SCC 566. Reliance placed on uncommunicated adverse entries in the SCR would not have been the grounds to deny the benefit of third MSCP to the petitioner. First up, it is not the stand of the respondents' counsel that there was any other ground for which the benefit of third MSCP was denied to the petitioner. If that be so, this court is of the opinion that the petitioner has made out a good case for interference in this case. As such, this writ petition stands allowed. The respondents are directed to ignore the uncommunicated adverse entries made in the SCR of the petitioner for the relevant years and thereafter reconsider his application for grant of third MSCP and pass appropriate orders therein in the light of observations made here and above within a period of 3 months from the date of receipt of a certified copy of these orders. First up, whatever be the decision, the same be communicated to the petitioner in writing within the aforesaid time period. Read petition stands disposed of.
My lord, deeply your lordship.
May it please your lordship. This matter, your lordship. Basically, we are concerned with the promotion of the private respondent. After the election, his promotion has been set aside by the Honorable Court. The promotion prospectively was not any problem, but with giving it retrospective effect is the issue we are here.
This matter will require full length hearing, right?
Obviously, on the last occasion, that is why your lordship has fixed it today, so that it can be heard, because the person concerned is retiring in June. And if he retires, then this matter becomes in practice. Because
June this
he is
year.
holding up the post, which actually I am entitled to. I am a senior because he's been given a retrospective promotion with seniority. And I am been stuck. Otherwise, I am a senior person to him.
Who is due to retire from in the month of
The
June?
respondent number 5, who has been promoted
Hmm.
against the order of this honorable. Against his earlier promotion was challenged and that was set aside. Now he has been promoted. Now promotion, I am not against it, but promoting and again giving him retrospective effect from the date when his earlier promotion was set aside, and then giving him the seniorities where it is. the
Wait a minute. What is your client at the moment? What post is he holding?
He is a development officer
In Rubber Board.
in Rubber Board.
When was he promoted to this post?
He was 2006. No, sorry. He was
8/5/21.
8/5/2021.
And when was the respondent number 5 promoted?
Respondent actually was promoted to that post. Your lordship will find. He was actually earlier promoted in 2014, was set aside. Then he was subsequently promoted, your lordship, which is under challenge in this writ petition, is by the order dated 1/11/2021, giving him the retrospective from 14/11/2014. Lordship will kindly see the order at page 1.
1 minute.
Yes.
So he is also a development officer.
Yes.
Both are
Now
development.
he has
officers.
been promoted as developer. Sir, then subsequently he is also considered for promotion to the next higher post because he has given the seniority from 2014. This is why the whole issue is now very important, because if he gets the promotion and he's holding the post, he is in ADO, he will be junior to me otherwise. Even if it is taken 2021. He was also junior to me as a field officer. Then this promotion actually he superseded in 2014. I came before this honorable court, it was set aside. Now they have come back by giving him promotion. It's no problem. 2021 is given a prospective promotion, no problem. But how can you give him a retrospective promotion from the date this honorable court has held his promotion to be illegal?
Where is the order of the court?
Order of the court, your lordship will find at page 117. There are a series of writ petitions. The particular case relates to one writ petition, one respondent. That is, your lordship will find at page 132 of paragraph with regard, because the other matters are also on a similar line, but it has a different ending because those cases were dismissed. This is the only case where the honorable court has interfered. It starts from page 117, but this case relates page 132. Page 132, para 17. The point was very clearly given by this honorable court. I'm not going to the other details, your lordship, since your lordship is asking specifically this part. In connection with WPC number Iman, the respondent number 1, 2, 3, the rubber board has not been able to show that in order to promote the private respondent number 13, in this case, he is the private respondent, the same, D. Suresh. Any DPC or supplementary DPC was held. Hence, the challenge to the promotion of respondent number 13 in WPC so-and-so is sustained, and as such, the impugned OM dated 29/10/2014 in respect of respondent number 13 therein is set aside, and making the interim order dated 14/11/2014 passed in WPC so-and-so absolute. So if your lordship would like to go to the interim order, that is at page 115. So there was a status quo order given, and after the status quo order, this final order was passed. So status quo order is at page 11, starts from 114, but it's 115. And the last page 116, there is a status quo order with respect to respondent number 13, D. Suresh. Here he is respondent number 5 in this present petition. So here what has happened is clearly set aside by this honorable court. Now, if your lordship will kindly turn to the page 134, this will, your lordship will see how it has been done. Kindly see page 134. This is the office memorandum dated 1/11/2021, giving him the retrospective promotion. So I'll read this. D. Suresh, by his representation dated 26/4/21, has requested to restore his seniority based on his earlier promotion order dated 29/10/2014, as per the judgment dated 23/3/2021. This judgment of Honorable Guwahati High Court. He was promoted to the post of development officer against SC reservation vacancy wide OM number so-and-so, dated so-and-so, based on the select list of DPC held on 21/7/2014. But due to the stay order dated 14/11/2014 of the Honorable Guwahati High Court in WPC so-and-so, D. Suresh was unable to join duty in the promotional post of DO. Later, by OM dated 1/7/2021, D. Suresh was promoted to the post of development officer in SC reservation category, but not reinstated his previous seniority. A review DPC was convened and the committee examined the case in detail. The committee recommended to reinstate the seniority of D. Suresh in the post of development officer as in the seniority list of DPC held on 21/7/2014, by which he was promoted as development officer. Accordingly, the seniority of D. Suresh in the post of development officer is reinstated with effect from 14/11/2014, the date of interim order of the Honorable Court of Guwahati in WPC so-and-so for maintaining the existing status quo, and his position is placed between so-and-so and so-and-so as per the then existing seniority list. The monetary benefit in respect of so-and-so will affect only from the date in which the D. Suresh assumes duty to the promotional post of development officer with effect from 2/7/21, and will not confer any right or claim other than the emoluments attached to the post. He will be eligible. This is another point which is very important. He will be eligible to be considered for promotion to the next post of deputy RPC by considering the residency period from 14/11/2014. So what happens? He gets the residency period he also gets for the next promotion immediately. Because if he gets that seniority, he gets the next promotion immediately because his residency period is complete within that period. So he's in 2021, he is getting a 7 years seniority, 7 years your lordship residency period. And that is the period required for the next post. So these are these directly in against the order of this honorable court, because the court has at that point of time set aside. And
So where is the recommendation of the DPC about reinstatement of his seniority or giving him a retrospective?
this is the order given, your lordship. I don't know.
This order refers to committee recommended.
A committee, that is a internal committee, they might be having that.
Where is this order?
This is the internal document, your lordship, I cannot have.
For the minutes of the DPC, I don't have notes.
But records were called for. Records have been called for.
Possibly, records possibly.
Records have not been called.
আমার order কি কাছে
Because in the meanwhile, they also filed an I
Lordship.
for vacation of the interim order. But
There is an interim order here.
yes, yes.
What is the interim order?
The interim order, your lordship, dated 7/1/22, it specifically states that this is in violation of the honorable court's order. Interim order, copy to,
But in the IA, we have annexed the order, my lord.
I ran a move that order to us.
So once the court says his promotion given in 2014 is illegal, how he has been again promoted with effect from that?
Malad, kindly see the region, Malad, why it was cancelled now. They kindly see the region, Malad. But the lordship, it starts at page 117.
Just 1 minute. Let me see the interim order first.
Lordship.
In the IA 44 page, your lordship, is the interim order.
Where is the 111/21 OM?
111 is there. Malad.
This is what we read just now. Page 134 of the writ petition, is it?
Yes.
Yes, yes.
Annexure G.
So there is a judgment of this court just 10 days back, Supreme Court judgment, the reservation roster cannot be used for seniority. It is only for promotion.
But the promotion was para 17, page 132, the promotion of the respondent number 5 here, it was cancelled by the honorable court because at that point of time, without holding any review DPC or supplementary DPC, he was promoted. Well, what has happened? The respondent number 5 was at the second place, but in the meantime, the person who was promoted for the SC post, he died in the meantime after 2-3 months. Vacancy occurred, and the authorities have as because in that particular DPC.
Oh, Mr. Nath,
Lordship.
when was he now as on date?
Lordship.
What is the date of promotion of the respondent number 5?
But it was promoted on 1/7/2021.
2021. Before that, he was not a development officer.
No.
Now, before that, he was not a development officer because the first promotion, it was without holding a review DPC. That is why court
Whatever,
said-
that, these are the grounds. It was set aside.
court has cancelled that.
Yes.
But in respect of
So
other
then first promotion goes,
logic.
the only promotion which happened was on 1/11/2021. Is it? 2021 he was promoted.
1/7/21. 1/7/21 he was promoted, but in the meantime, another officer who was promoted as SC in 2016.
Hmm.
She approached the Honorable High Court at Kerala High Court. Kerala High Court has disposed of the matter, considering that her representation to be considered. But I'm just passing the order. But I'll take your lordship to just.
You don't have the judgments, huh? The reservation roster cannot be used to give seniority. That
These
judgment-
judgments, I have, actually, I have the judgments. Today I've been doing that judgment because I am basically concerned with the case
But
of
before I take your,
retrospective promotion.
but this is the judgment filed by one of the SC candidate who was promoted in 2016. And in the gradation list at page 135 of this writ petition, if kindly comes to page 135
Hmm.
of this writ petition, Lord,
Yes.
she is at serial number 4.
The lordship has been, has referred to this judgment, Union of India versus Manpreet Singh Poonam, 2022 6S.
No, there is another judgment.
This I have got in fact.
Lord,
So
kindly come to the gradation list annex in the writ petition, page 135, Lord. Serial number 4, Balsala Muthukkal. she was promoted to the post of DO Malad earlier on 26/2016. But because of an interim order, she could not join. Those writ petitions were dismissed by the common judgment. Plus she filed a representation, it was not considered, therefore she approached the Honorable Kerala High Court. Kerala High Court said that the representation of the petitioner, that particular petitioner is to be considered. But this serial number 4 in the gradation list and the private respondent here, he is at serial number 2, they are similarly situated persons. When that representation is to be considered, the private respondent also filed a representation before the authority that his case is to be considered along with the particular the person at serial number 4. While considering that, the order of 111 was passed. In our affidavit, we have explained, if Lordship kindly.
So according to you, these are similar situations. One promotion given due to interim order, the person could not get the effect. So writ petition dismissed and that person sought benefit of promotion
No,
from the date of the.
now-
This is
now-
one case.
No,
Listen,
that is.
Another case is promotion given challenge, court set aside the order of promotion.
Because
Both are in the same footing.
no, because without holding any DPC.
Mr. Nath also at the end of the argue why we should not impose a cost of 1 lakh rupees in this case. Please argue on that also. This is all totally unacceptable.
No, but Lordship may kindly consider, my lord. Kindly come. to
Court
affidavit.
clearly says that the promotion given to the private respondent earlier is illegal. It was held without a proper DPC, so it was set aside.
Now the review DPC has been held. DPC has taken a decision after considering the entire.
What is the review? Where is the question of review DPC here?
But in our affidavit, we have explained, my lord. Kindly similar, that particular vacancy for SC, it was there in
That
2015.
cannot be done. That's what I'm saying again and again. He doesn't have the judgment, otherwise I would have dictated it. Vacancy might arise anytime. That is precisely what this court has decided 10 days back.
Kindly, Lordship, see these two judgments.
Where is the
But
judgment?
I think
You can,
Well, under the what circumstances this has been done, we have explained in the affidavit, my lord, that Lordship.
No, Mr. Nath.
Please. I
reservation
got it.
brings, if a person does not come within the zone of consideration through his or her seniority, if there is a reserved vacancy, against that, a reserved category candidate can be considered
Lordship.
irrespective of the seniority position.
Lordship.
But once the promotion process is held, it is one consolidated list of promotion. There, can you say that this vacancy arose 5 years back, so you will get a seniority 5 years before the others? This is precisely what the Supreme Court says it cannot be done.
But in
You
that
cannot
case-
use a roster. Your argument of a vacancy arising on a particular date is on the basis of roster argument, nothing else.
Roster argument.
By roster, you cannot give precedence to promote seniority. That's the law.
If your lordship kindly takes the
Well,
2022
only-
judgment, 2022 6 SCC 105, here the retrospective promotion part has been dealt with. Here the same thing has been said, but in latest one I don't have. Para 21, kindly lordship will see. What your lordship has just stated is also given in para 21 here. 20, para 20. Has clearly laid down that a promotion to a post should only be granted from the date of promotion, not from the date when its vacancy has arisen as observed by that. Then 21, a consistent line of precedence of this court follows the principle that retrospective seniority cannot be granted to an employee from a date when the employee was not born on a cadre. Seniority amongst member of the same grade has to be counted from the date of initial entry into the grade. So initial entry, I'm seeing I was a development officer much prior to him. Then he was given this promotion after that.
Anyway, I have understood the case, but would like to go through the judgment of the single judge. That is single judge to find out what exactly had happened. Let us read the judgment 23.
Yes, there are two phases. Just before that, I'll just make a point.
Mr. Nath, we'll hear you,
Not.
but that is the point here.
Malad.
Please don't argue against settled law. Either you
No, definitely.
distinguish it or accept it.
Definitely.
Because
Malad,
unnecessary wastage of time.
we have taken a stand here. If Malad, I'm not aware of that, Malad, I'll definitely examine. I'll examine that.
The two facets of the judgment is that there are two series of cases, about 4-5 cases. One is the challenge to this particular respondent number 5, his promotion.
No, I am not
The
for the respondent.
other is in the judgment of the honorable
Who is
single.
appearing for respondent number 5?
Mr. Abha was there. The last time I told him, he said he's not inclined to appear. I don't know. Mr.
Who
Abha
is there, Mr.?
I am for the authorities. Mr. S.R. Radha person.
All right.
Before going into the judgment, there are two parts.
But where is this gentleman? Can you find out? Because what happens is if an adverse order is passed,
Very rough.
they immediately come and file a review petition.
In fact, I told him on the last occasion, when your lordship was picking up the matter on the last occasion, I told
Can
him.
you ask your junior to? just
Yeah.
sign?
So what has happened here in the judgment, there are two facets. First is that there was a challenge to a normal procedure that has not been followed in promotion, and second part is challenge to his promotion specifically. The others are with regard to the seniority given to them after promoting them and superseding the seniors. That is the two parts. The first part, this court has dismissed this writ petition, going against it. That is under challenge in a division bench in 2 writ appeals. The name of the writ appeal numbers I'll give. That part, your lordship, actually I'm not going into that part because of the fact that that is in a different proposition with regard to the procedure adopted in promotions of the other persons in the other cases. And in this case specifically, this point was taken up that it was not followed. Therefore, it was sentenced. So that is, so judgment, if your lordship want to read, I can read the whole judgment, your lordship.
Yes,
That your lordship will find.
yes.
From page 117, but
There were 4 writ petitions which were decided.
yes, 4, but the other writ petitions are on a different footing. That is on clubbing of vacancies. And if I read and I go through, then I have to even set judgments with regard to that also. Clubbing of vacancies, they have not they clubbed the vacancies of many years together, and then they brought in the extended zone of consideration. That was one ground which is challenged. 50% quota has been breached. That is another challenge. And third challenge was
Your initial appointment was field officer.
field office. So I was a field officer. Just a moment, Lordship. I'll just. Lordship will kindly take up. I was appointed as field officer in 15/2/1989, junior field officer, JFO. I can give a list of dates also if your lordship wants.
Where, give me.
But this is actually top part na lage na. Yes, here, your lordship, appellant was initially appointed as junior field officer in 15/2/1989. In 31/3/1994, a gradation list was published, wherein the petitioner was at serial number 29, and the present, your lordship, respondent number 5 was not there. Was at 125, sorry, serial number 125. So I am at
Have you
20.
given him a copy of this list of dates?
This list of dates, I can give him a copy. Just a moment. I have an extra copy. Okay, yes. এই আমার daily copy to একই। Division bench copy to একটু মোটামুটি একই। So 31/3/1994 was the first gradation list, where I am at serial number 29 and the respondent number 5 is 125. I'll not go into that. There is no dispute with regard to that. So I was promoted to the field officer on 16/4/1996. Your Lordship, then another gradation list was published on 31/12/1998.
And when was the private respondent promoted field officer?
Field officer, he was promoted, that promotion, just a moment, Lordship, I can. His promotion to the post of field officer was much later because he was not there at the gradation list at that point of time. I just want to show that. He has come subsequently, obviously his promotion was much later. So your Lordship, he nine, Lordship will kindly for a moment take up page 66. Page 66, the chart, this is the gradation list. I am showing this because of the fact that I have been promoted and then I have been placed at this list, your Lordship, of 31/12/1998 gradation list. Lordship will see my name is at page 71. Page 71, that is serial number 149. And after me, there are only 3 persons: Midul Chaudhary, Rashmi Rekha Majumdar, and Jesse Joseph. Just Rashmi Rekha Majumdar is another writ petitioner in the other writ petitions before the writ appeals before the division bench. So
Now, what does this, your list of dates is, see para 4, last
Yes.
line, the name of private respondent number 5 was found place. What does?
none of the private respondent name found place. So the private
No,
respondent.
no, page number 2 of this. 31/12/1998.
31/12/98. 31/12/1998.
Mr. Mannan, on the next date, I will request you to please give me a proper list of
Okay,
dates.
I'll provide.
Because we have to write a judgment.
Yes, yes.
Yes.
Actually, I was not inclined to give it because I found there is some, I corrected these and there some corrections are required. Corrections other baki khini logo milai dila je. Anyway, your Lordship, here I would like to show page 71. Correct for divide. Page 71, your Lordship. My name is at penultimate one, 149, Prasanta Burwa. So there are another 2 persons below me, that is Midul Chaudhary, Rashmi Rekha Majumdar, and Jesse Joseph. So immediately after my promotion of field officer, I am at serial number 149. So obviously, the respondent number 5 is nowhere there at that point of time, so he was not promoted. Subsequently, he was promoted, your Lordship. At that point of time, then on 2/6/2006, your Lordship.
Mr. Manan, on Tuesday, proper list of dates, and please look up the judgment. I can't hear this matter like this.
Anyway,
There are
I'll look up-
multiple writ petitions, etc. Please make
Okay,
a
that will
proper
be
list,
better.
give him a copy,
Yes.
and we'll finish it off on Tuesday, 23rd. That's fixed parted matter. You take back these judgments.
I'll get the new judgment that your Lordship has
Yes,
referred.
I'll come.
Has any, when it is, any idea? Recent,
When do you want it? 23rd, 23rd May? 23rd
year.
May? This year?
No, no,
23rd May?
No, the judgment.
You want it next year?
No,
my-
I'm asking
my
about the judgment that your
senior is
Lordship has
okay on the
referred.
judgment.
Is it a recent judgment?
2 weeks back.
Okay, I'll get.
Heard Mr. Y.S. Manan, learned counsel appearing to the petitioner, also heard Mr. D. Nath, learned counsel appearing for respondent numbers 1 to 4. That
2
is
to
the
4.
double vote. 2 to 4.
2 to 4.
Who is for 1?
1.
I'm appearing for 1.
Uh,
P for Gary.
This P. Surgari, learned counsel has appeared for respondent number 1.
Normal judgment.
And Mr. Nath for 2 to 4. None has appeared for the respondent number 5. Although the name of the learned counsel for the respondent number 5 is shown in the cause list. Be that as it may, on the request of Mr. Manan, this matter is directed to be posted again on 23 5/2023 for further hearing. This is the judgment. Have a look at it. Let me see once. Bimalesh Tanwar's case. Bimalesh Tanwar.
Demolish time.
2003 5 SCC 604. It has said 16(4) will only be applicable for giving a chance to the backward community people to get promoted or appointed. But it will not
Give the senior.
be used to give seniority.
I'll check. Much obliged.
Lordship, I pray for a short accommodation, Lordship. Instruction summer receipt which is inadequate. 2 weeks time may be granted, Lordship.
We don't have any objection to that, but only the fact is that the matter has been prolonged now. 1 year has already passed since the last order that was passed.
What is the matter about?
It regards to appointment in for
Selection and appointment in Central Armed Police
Constable DT
Forces.
post. That was published by the Staff Selection Commission in the year 2018. Advertisement dated 21/7/2018.
Heard Mr. M. Fukan,
I'm WR Mehdi.
W.R. Mehdi, learned counsel for the petitioner. Also heard Mr. B. Chakraborty, learned CBC, appearing for the respondents who submits that he has received some instructions, but those are inadequate to file an affidavit. Therefore, the learned CBC seeks 2 weeks further time to complete his instruction. Prayer allowed, let this matter be listed again after 4 weeks. In the meantime, the respondents shall file affidavit bringing their stand on record without fail.
Obliged.
Lordship, I wanted to argue for a disposal, probably time will not be. Because
Yes.
this regard, the petitioners are employees of the principal seat of the Honorable Guwahati High Court. And their basic grievance is non-conferment of benefits of revision of pay under the ROP 2017, as a result of which they are getting lesser pay since for the past 7 years. And these are the set of employees who were appointed prior to the publication of the ROP 2017 and after the date on which these rules have been brought into effect. And
Do you have a list of dates here?
Lordship, a list of dates, we have prepared a short synopsis. Lordship, now their whole grievance has arisen due to the fact that the Act provides a certain in a certain mode by which the set of employees who were appointed prior to the publication of the rules and after the date when the rules have been brought effective, the manner in which their pay ought to be revised. And pursuant to the filing of this application, that procedure has been, the Finance Department has given concurrence to that procedure. But what they have done is, while making the calculation of the basic pay itself, as your Lordship knows, so far as the employees of the principal seat of the Guwahati High Court is concerned, the basic ingredient of their basic pay is principal seat pay. And that PSP has been wrongly applied. And that is why even now, though they have approved that mode of revision of pay, but the wrong application of PSP has resulted in against the lesser pay. Lordship may kindly peruse this for me.
They are all principal seat employee.
Principal seat employees. They're working as computer
So
assistants.
it is about calculation of the slab.
Not slab, the manner in which they were brought in under the ROP 2016.
Now, see, the problem is this court cannot say which, in what manner, which pay scale should be given.
No, no.
These are the
That is
job
not
of.
required, Lordship, that is not required. It is about application of a notification. Because the PSP, in the manner in which the PSP is added, that is pursuant to a cabinet decision and that has been approved by a judgment of the Honorable High Court.
Hmm.
So
Where
now,
is that judgment of the High Court? Is it part of the record?
yes, there we have enclosed it in the IA, but for.
All right, I have the IA.
Yes,
You can refer to the IA.
yes.
What is the IA number?
There's only one IA 313.
Yes, I have it.
Yes.
Which
313.
order you are referring to?
Judgment is not enclosed here. If your Lordship peruses that notification at page 28 of the IA.
Yes.
In compliance of the Honorable Guwahati High Court's order dated so and so, passed in WPC so and approved as approved by the cabinet in the meeting dated so and so, the Governor of Assam is pleased to approve the payment of principal seat pay to the officers and staff of the Guwahati High Court, principal seat as interim measure as follows. The officers and staff of the Guwahati High Court principal seat will be paid principal seat in addition to their existing emoluments, existing pay and allowances in the following scale. We are not concerned with the scale because this has been rightly given. Lordship will kindly peruse serial number 3. Principal seat pay shall be admissible to the officers and staff of the principal seat of the Guwahati High Court in addition to their respective pay in the pay band and grade pay. The determining basic pay to determine basic pay, that is basic pay equals to paying payment plus pay grade pay plus PSP. This is how the basic pay of the employees of the principal seat is determined. These three are the essential ingredients for determining the basic pay. Now, after the finance department, while giving the concurrence, what they have done is that they have calculated our basic pay on just paying payment plus grade pay. And they have added, while calculating the annual increment, they've excluded the PSP, which they cannot, because the PSP forms an integral component of the basic pay and the increment has to be given on the basic pay. That is why that is where the even now the salary, the pay has wrongly even fixed, even though they have approved the procedure as prescribed by the ROP 2017.
So they have not included PSP in the basic pay, definition of basic pay.
Excluded the PSP. Now at the time
that is your grievance.
Yes, now at this point, pursuant to the filing of the writ petition, the finance department has given concurrence to the procedure that has been prescribed in the ROP. But they have, while calculating the pre-revised pay as well as the revised pay, they've excluded the PSP while calculating the increment, because the ROP provides that while these set of employees, in the manner in which this set of employees should be brought in under the.
So in other words,
yes,
if the authorities would have included PSP in the definition of basic pay,
yes,
so as to calculate the increment that would be due to your clients,
yes,
under the ROP rules of 2017, then your grievance will be redressed. Is that correct?
Yes, that is how they, first of all, they ought to have determined the pre-revised pay. After that, determining the pre-revised pay, they ought to see against which table and which slab it fits into the as has been annexed in the ROP 2017.
So, all right, according to you, supposing PSP is accepted, then the basic pay of the petitioners will be rupees 8,750 under the pre-revised rule. Is that correct?
Yes.
Now, what is the pay band corresponding to 8750 in the revised pay rule?
Corresponds to 17,210. In the fitment table 1.7. If your lordship takes up the ROP.
Sorry?
If your lordship takes up the rules, ROP rules.
These things will require a little,
Yes.
this bench is
Yes,
again
yes.
sitting after rising of duty. Huh? You tell the bench that if time permits, if not today, from next Thursday onwards, you should write that the single bench will again sit if time permits. That should be mentioned in the notification. Can you give a comprehensive note on what exactly is that your clients are seeking to canvass? Mr. Sharma, these are all very
Lordship,
technical, but then mathematical.
Your
issues.
Lordship.
It seems the notification dated 16/8/2015
Yes,
clearly
yes.
says
That,
that basic pay would also include PSP.
being the judicial department, when we received this from the High Court Lordship, we have sent it to the Finance Department, PRU, for their concurrence or clarification views. And thereafter, Lordship, we have not, this letter was sent on 9th of March 2023 to the Finance Department, but have not yet received any from them. Lordship.
That is, we have.
As because
Filed our affidavit and this is why we have filed the. Lordship, concurrence has been received. That is why we have filed the IA that the concurrence has been given, but that is the error they have made there regarding the application of the PSP.
That's right, Mr. Nayak, what she's saying.
No, my friend may not be correct, Lordship. In my humble understanding, whatever the prayer was there, Lordship, that has already been given, that relief has been given to her, Lordship. One paragraph I would like to.
There in the writ petition.
Yes, Lordship. It was only.
So according to
as
you,
regard
they have been given, the PSP has been included in computation of the
Yes,
basic pay.
it is always there, Lordship. Always there, Lordship.
Then both of you will have to come up with your.
That is why, Lordship, on
protections.
last date, Lordship, on 27th.
Lordship, we'll hear it in details. I'll.
In response to this affidavit, she was directed to file her reply, Lordship. That is not.
Reply. We filed the reply. Hello, this will copy in India, get a file now.
Reply in writ
In
petition.
response
In
to
all
the,
the
no,
affidavits, we have filed the reply. Affidavit filed by the judicial department.
So you take down Miss D. Borgohain and counsel is present on behalf of the petitioners. I also heard Mr. H.K. Sharma, H. Sharma, learned additional senior government advocate Assam appearing for the judicial department. Mr. P. Nayak, learned standing counsel finance department, as well as Mr. H.K. Das, learned standing counsel GHC appearing for the respondents. Respondent, see the respondents, huh?
3 and 4.
All right. The writ petitioners herein are all employees of the principal seat of the Guwahati High Court at Guwahati. Full stop. According to them, the respondents have not included the PSP, principal seat pay, PSP, in the computation of basic pay so as to fix their pay under the pre-revised pay scale. Therefore, there has been an error in revising the pay scale under the ROP rules of 2017 by comparing it with the correct position in the fitment table. Full stop. The aforesaid submission of the petitioner's counsel has, however, been strongly refuted by Mr. Nayak by submitting that PSP has been included in the computation of basic pay, and the petitioners have been granted all the relief prayed for in this writ petition. Full stop. However, Mr. Nayak submits that no copy of the rejoinder affidavit filed by the petitioners in this case has been served upon him till today. Under the circumstances, this court is left with no option but to list these matters again for admission hearing. This is admission hearing,
Yes,
right?
admission.
Admission hearing after 3 weeks as fixed item. Ms. Borgohain to submit a copy, to furnish a copy of the rejoinder affidavit to Mr. Nayak within 3 days from today. You are also appearing.
Yes, similar, bit difference.
On the next date fixed, the learned counsel for both the sides to come up with a brief note on projection of financial benefits claimed by the petitioners, and also the response of the finance department in this regard. Let this matter be listed along with WPC number 419 of 2023. And in 419, Mr. A. Shamwa for the petitioner, so and so, so and so. So let this be sorted out and then.
In my case, my lord, the affidavit has not been filed.
Yes,
One document I would like to show from my case, maybe possible.
What for? We are fixing it after 3 weeks.
My lord, this will clarify one issue, my lord. If,
You are seeking a final disposal order
no,
today.
my lord, this document is lordship said for one month. That the finance department has, High Court has written to the finance department, judicial department and finance department for 2 posts. One for the personal assistant, senior personal assistant, and one for the computer assistant. But the finance department, for the reasons best known to them, they have given concurrence to only computer assistant, leaving aside the senior personal assistant. That document I have annexed. So that they have to clarify why.
I'll take instant. In this case also.
In item 14, you write so and so for the petitioner. Mr. Nayak prays for and is granted 2 weeks' time to file affidavit responding to the allegations made in the writ petition. Let this matter be listed along with item 13. Now, item 14, after 3 weeks, as fixed item.
It's a date.
3 weeks, fixed item.
Item 15. For hearing.
But this writ petition is against the penalty of reduction to a lower stage in the time scale of pay by stages 4 years by the disciplinary authority. And some,
We'll be able to finish in next 5-7 minutes.
that's one, it may be fixed on Tuesday.
No, it can't be before 15th June. Not possible. Choose a date after 15th June. So and so for petitioner, so and so for respondent, or straight for counsel for the parties. This matter will be listed again for hearing on 20th of June. 20th of June. Yes.
Next second of mention.
Similar order make up for item number 20, because it is,
Item 20, yes.
though it is a very short matter, it will not take much time. So I did make me fixed.
Item 17 and 18.
My lord, this both the matters related to the dismissal from service. And it will take some time. Can it be taken up on the 15th June, lordship?
22nd June.
22nd.
Post this.
Item 19.
May I please allow? My lord, this case relates to the dismissal from the service, my lord, by impine order. We preferred an appeal, my lord, without entering into the merits. They dismissed the appeal on the ground of limitation, my lord. So it may take some time, my lord, as your lordship's convenient, my lord.
22nd June.
Lordship.
Item 20. Oh, 22. Item 22. 23.
Give it after 22nd June, all non-miscellaneous days fixed. You give the date when you want non-miscellaneous day, after 22nd June. Let us list it on a day when it can be heard, otherwise it will be keep, this matters will keep coming in the list.